in the matter of the City of Wyandotte versus Robert Allen, 241508. A good morning.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Robert Allen. Your Honor, there is an oral motion that I'd like to make, actually two.
Okay, so Mr. Allen, your name for the record, please.
Robert James Allen.
Okay, so today's date scheduled for sentencing in this matter. This was adjourned from April 28th. And counsel.
Yes, I was just so court to where, Your Honor, Mr. Allen did renew his medical marijuana card. He brought it with him. But the motion is, well, the first motion would be Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. Is without breaking attorney-client privilege. He doesn't believe that I properly advised him. So the first motion would be to allow Mr. Allen the opportunity to withdraw his plea in the interest of justice. He so chooses. All the witnesses are police witnesses, and all the evidence is captured on body cam and video. So I don't think the prosecution will prejudice. The second motion.
Well, hold on. Before we move to the second motion, I'm not going to even consider an oral motion to withdraw a plea. That all has to be done today. So the prosecutor has an opportunity to respond.
Understood.
Because this plea was taken on March 12th, so now we're over 2 months ago, and I need to be able to review the motion to determine whether or not that is something this court would grant. And counsel, your next motion.
The second motion, Your Honor, would be, since there has been a breakdown in the attorney-client relationship, I would respectfully move to withdraw from the case so Mr. Allen could either secure new counsel or request court-appointed counsel so that they could properly file a motion. I don't know if they want to file against their hearing or anything, or if the prosecution would be in opposition to it.
Okay, and so counsel, when did this all come about?
Well,
Did it come about this morning?
We have been discussing it for a few weeks, and this morning it just came to a head that I can't effectively represent Mr. Allen anymore in line with what he believes to be his best interests as opposed to my conflict with what's happening here.
Okay.
I was retained in a candor with the tribunal. I was retained by a third party who did give me $2,000 to represent Mr. Allen. I proposed that I refund half of that to Mr. Allen at a minimum so that he could.
You refund that to Mr. Allen so that to the third party?
To the third party. But basically, if they wanted to help him again, I can't in good conscience or refund all of the retained revenue down here several times to put into this matter so far. So I will be refunding $1,000 to that individual.
Okay. So my question is, counsel, if this was something that was a possibility, why there wasn't a written motion filed before this morning?
I literally believed everything was fine when I was informed of the medical marijuana card, and that was just the cold feet issues that some of my clients have, and until they give me like clear, unequivocal, I couldn't interpret. I didn't know. You didn't tell me I want to withdraw my plea in any other light than, okay, you're telling me you believe I was ineffective at this point, and what my thoughts aren't in line with what his beliefs were during these last few weeks. So I do apologize. You're correct that if I knew, I should have filed a written motion, but we discussed it. I said I could withdraw as your attorney, you could find someone else and things like that without getting into the nitty-gritty of it. But it was my belief that the representation was still intact and we were on the same page. And I apologize for interrupting the proceedings earlier. That's when it basically clicked that this is something that I need to bring forth and make these requests.
Okay. Mr. Allen, you have been to court a number of times with Mr. Alana, correct?
Yes.
And you've had opportunity to speak to Mr. Alana on a number of occasions, correct?
Yes.
And you also have had the opportunity to review discovery with Mr. Alana, is that correct?
Yes.
Okay. And Mr. Alana has been your attorney since January, and there's been a number of court dates that have been scheduled. In fact, you all were here April 28th, and we did not hold the sentencing because your client indicated that the CCH was inaccurate based upon what you had represented and requested time to adjourn that to revisit that issue.
And it has been corrected by probation, Your Honor.
Correct. Would that be correct, Mr. Allen?
Yes.
All that is correct, right?
Yes.
Okay. And so now here we are at the date of sentencing, and you want to have a different attorney, and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea because I don't feel, first of all, probation ain't even part of the punishment for what I pled guilty to. I took the plea agreement thinking we're going to sentence me accordingly to what the first offense misdemeanor is for.
Okay. So
You're trying to put me on probation, and that's not even part of the punishment.
Pause just a moment. What is it that you believe is the punishment for a first offense misdemeanor?
Miss MCL 750, whatever else it says on there, the punishment is only 93 days in jail, $300 maximum fine, community service, a 90-day, 30 to 90-day license suspension, and up to 4 points on your license. I already got the 4 points. I already got the 90-day maximum suspension. I know you're going to charge me the $300 maximum fine. I feel like that's more than enough punishment for a first-time misdemeanor offense. I've never been arrested for anything alcohol related in my life. I'm 48 years old. Never been in trouble in Wyandotte. You're trying to, the clean slate law is supposed to erase my whole record. You're not even supposed to be bringing up my past record on me. Not the probation department lady already lied on me, put stuff on my record I wasn't even convicted of, putting 12 to 18 months probation. That's not justifiable for punishment for what I did. What I did is it doesn't even include probation for the punishment.
Your Honor, Mr. Allen's statements to me was I did not disclose to him that probation was a possible sentence.
Probation ain't part of the punishment.
Mr. Allen.
So I want to pull my plea because
Stop interrupting the record. Your attorney is speaking right now. Just one moment.
And I do not recall telling him that yes, probation could be part of the court's sentence, or that no, probation wouldn't be part of the sentence. I just assumed that Mr. Allen knew that probation could be part of the court's sentence.
Okay.
So
it's not part of the law.
I understand that, sir. Nevertheless, Your Honor, there has been a breakdown in this relationship, and I can no longer, in good faith, continue this representation. Mr. Allen, not only for the defendant, protecting the defendant's interests, but also now my own interests, because I'm in a position where I could be looking at a possible grievance if I continue representation at this juncture.
Okay. Mr. Allen.
Yes, ma'am.
So you're telling this court that the matters that you have on your criminal record, that those have all been dismissed?
No, I said I qualified for the clean slate law, and it was my understanding that my past record would not be brought up against me. But here I am, and everything on my record is.
We're gonna take one thing at a time. You understood that you were eligible for the clean slate law. So what does that mean to you?
The lady the representative told me that we went over my record, the CCW on my record, the false report of a misdemeanor, the attempt to receive and conceal, all that was supposed to be erased off my record. It was never supposed to be brought up against me ever again. I was told if I got in trouble again, that none of this would be brought up against me. It would be like I'm getting in trouble again for the first time. So, therefore, the probation.
Which convictions are those, sir?
Huh?
Which convictions are those that you're speaking of?
The CCW conviction from 1997, the false report of a misdemeanor from 2004, and attempted receiving and concealing from like 2012 or whatever, or 2010 or whatever that year was. All of them are more than 10 years ago. You may be supposed to be bringing this up against me.
First of all, 2010 isn't on here.
Well, whatever the year was for the attempted receiving and concealing.
Okay, that's not on here, sir.
Okay, so well, everything else, so there shouldn't be nothing on my record.
That's not true. That's not true.
What? There shouldn't be nothing on my record then.
You have a number of criminal convictions, more than just what you spoke of. In the clean slate law, there are certain convictions that are automatically wiped off per the Michigan State Police, from the Michigan State Police per that law.
Yeah,
Sir. The court is looking at some of these, and if you
are trying to prosecute me for my past,
sir, the court doesn't prosecute. Let's clarify that. The court doesn't prosecute. If you are eligible for any of these convictions or to be removed from your record, then you have to follow the steps that have to occur. Right? There's motions to set aside, there's applications, set aside convictions, and whatnot. So those are the steps that have to be followed. Some of these are not automatically wiped off.
Can I say something? I was told since I was a Detroit resident that it does automatically get wiped off. I didn't have to do nothing. The system would automatically update itself. As a Wayne County resident, that's what I was told.
Detroit resident or Wayne County?
Detroit resident. I'm sorry. As a Detroit resident, if the system was supposed to update itself and erase itself, I didn't have to do nothing.
Okay, so I have to tell you that's the first I've heard of that. I haven't heard that anything is resident.
Well, you probably haven't had to have going down there talking to somebody had your record expunged either.
Sir,
ma'am,
I'm still given the laws to review when they're passed and then they're enacted. So I don't recall seeing anything about being resident specific. And then why would it be only a benefit of Detroit residents if it's a state statute? So whatever that is, I don't know. I don't know if there's a misunderstanding somewhere. I don't know.
Ignorance ain't no excuse for not knowing the law.
You're correct,
That's
sir.
what you tell me. That's what you would tell me.
Don't presume what I would tell somebody for you. Do not presume that, sir. Now, as well as whether or not probation is something that is a possible consequence, okay. Probation is something that the court would order in lieu. Sir?
Surely.
Those gestures are not necessary. The gesture of money, money, money. Not necessary. Right? No. Probation is something that courts impose in lieu of jail, sir. Now, under MCL 769.5, have you reviewed that one, sir?
No, I haven't.
Okay. But I would suggest you review it because that gives the court judicial discretion if it determines that there is a rebuttal, that the presumption has been rebutted to sentence somebody to probation. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail if that's what the court determines it's going to do. The court also has the right to impose fines and costs only. The court has a lot of judicial discretion, sir, in imposing sentencing. So,
with all due respect, I apologize. I just feel like the recommendation by the probation department is way too harsh for a first-time misdemeanor offense. That's all I'm saying.
Okay, and sir, you have the right to have, sir, you have the right to have that opinion.
I just wanted to say that, Your Honor. I apologize. I'm not trying to be disrespectful. I just don't agree with the punishment for the crime. That's all. If you put me on probation, I feel like you're setting me up for failure.
And why is that?
Because first of all, I'm on SSI. My $900 a month is gone before I get it. I don't have no thousands of dollars to give you. My license has been suspended.
Let's clarify. You're not giving it to me, sir. Let's clarify. You're not giving me money.
But I'm saying I don't have any money to give anybody. Is what I'm saying. The 90 days, my license has been suspended for the maximum 90 days. I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out. I'm sad. I'm depressed. I'm sorry.
Okay, sir, I can understand and appreciate all of that. But let me just clarify.
This is my first time.
Let me clarify,
I
sir.
feel like this is more.
This court does not suspend your license. The Secretary of State did that.
I understand that, but it's still a punishment, a part of the law of the punishment. And I'm going through that punishment. And now I'm hurting because I can't see my own kids now.
And why can't you see them?
Because my license are suspended.
They can't come to see you.
My son don't have a car. You know what I'm saying? My daughter, she goes to nursing school. She's a full-time mother
Okay, so where does your daughter live?
in Woodhaven.
Okay, and you reside,
I live in Detroit, and it costs a lot of money to take an Uber back and forth that I don't have the money for.
okay, what a bicycle? What about a bicycle? What about someone
I'm
else?
disabled. I'm gonna ride a bike from Detroit to Woodhaven.
Sir,
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
And sir,
You're trying to punish me too much for a first-time misdemeanor offense. I've never been arrested for anything alcohol related. This is a 90-day misdemeanor. You're talking 12 to 18 months probation. That doesn't fit the punishment of the crime, man. That's too harsh. Even with the criminal record that I have, 12 to 18 months probation is too harsh. I haven't committed any crime. I haven't been convicted of anything in more than 15 years. This is the first time misdemeanor offense. It should be a fine and my license suspended and have a nice day, sir. If I come back here again 2 or 3 times to keep drinking and driving, yeah, then I can see getting 90 days and all these probation and all this. But this is the first time misdemeanor offense. I feel like you're being way too harsh on me.
sir, I haven't assessed anything at this point.
But I already know what you're gonna do. I sat in your courtroom watching sentence 10 people. And ain't nobody walked out of here with under $2,000 in fines, all kind of probation and everything, bro, for misdemeanors.
Okay,
This guy just got all this for all these probations and did 2 years probation. And he did assault and all this, and you're trying to give me 12 to 18 months probation for a simple misdemeanor?
sir, first of all, your
How could they even recommend that?
your conviction is eligible for early discharge. So if you want to start comparing the
It's not
cases,
eligible.
stop interrupting me. Stop interrupting me. If you want to compare cases, then you need to have all the facts. You don't know all the facts on every case. This court takes every case, every individual that comes before it, and reviews the report, the recommendation, criminal history, what other special circumstances there are before this court fashions a sentence. Now, it may seem from your perspective that they're very similar because some circumstances, right, some offenses benefit from similar rehabilitative conditions.
Simple misdemeanor charge, man.
That's your opinion, sir. That's fine.
Blown out of proportion. That's all I'm saying.
Well, sir,
If I
you
go
also
back
have
2 or 3
you
times
also
to
have the
drink,
reaction of after you consume the beers to have somebody else drive you home, then you wouldn't be here.
you're right. And I really want to go to trial because making me blow 13 breathalyzers and charging me with something that with only one, you know what I'm saying? I was falsely arrested anyway. I was falsely arrested. The officer told me, I don't like how you're talking to me. If you don't quiet down, I'll take you to jail for disorderly conduct. That's not disorderly
Okay,
conduct.
stop. You're done. I'm gonna.
I want to withdraw my
Sir,
plea and go to
sir,
trial.
Sir, stop talking, please. Stop talking. The court's going to grant Mr. Alana's motion to withdraw. Based on the breakdown of the attorney-client relationship as far as the direction of resolution, it appears that there's a clear difference of opinion. Mr. Allen, are you intending to retain?
Oh, yes,
Other counsel?
I'm going to hire another lawyer. Somebody that's going to fight for me. I took this plea to be cool, you know. I wanted to go to trial the whole time. I
Sir, you don't need to keep talking. Stop
Okay,
talking.
I'm just
Stop
saying.
talking. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn. So, sir, when you have someone, whoever it is that you're going to be speaking to and retaining, when your attorney sees that on the docket it's scheduled for sentencing, that's because that is what's currently on the docket for procedurally. There's not been a written motion to withdraw the plea. This court's not going to entertain an oral motion because the prosecutor has an opportunity, has to have an opportunity to review the motion and file a response. So we'll adjourn the sentencing.
So I'm not gonna be able to pull my plea and go to trial. I'm just gonna be able to hire another lawyer for sentencing. Or am I gonna be able to?
Sir, do you listen to what's being said, or you just listen? What do you say? What you gotta say?
I'm listening to you.
What
And I'm asking for clarification.
What I said, sir, was that it's going to be scheduled for sentencing because that's what's currently procedurally scheduled.
I
There is
understand
not,
that part.
there has not been a written motion received by this court yet.
Okay.
So once there's a written motion, it will be set for a motion date.
Okay.
But as of now, this court's not just going to set it for a motion date because I have no idea who you're going to retain and what that attorney's strategy is going to be.
Thank you, Your Honor. I just wanted clarification. I'm sorry. I apologize.
You will adjourn sentencing to be June 18th. At 9:30 a.m. That's a Wednesday. And I did that so that in the event your attorney files a motion to withdraw the plea, it will be set on a day that's a wind-out date. So that will be a motion hearing date. Now, sir, I'm sure Mr. Arvada is going to tell you that there's procedure for motions. Notice has to be given so that you need to retain an attorney sooner than later. If you're in a test right now, sir, what's in your system?
Just marijuana, Your Honor, like always.
And when did you obtain this medical marijuana card, sir?
I went and got it like probably 10 days ago.
Okay. And so did your treating physician give you any documentation to?
My primary caregiver, she retired, Your Honor. So
No, sir. I asked you your primary caregiver.
I mean, not primary caregiver. I mean, my primary care visit. My primary doctor I used to go see,
Okay.
Wendy McKay, she retired. So I don't have no way of like going in and talking to her anymore or nothing. So
Okay, when
I
did
would
she
have to
retire?
get it, a couple of years ago.
Okay, so who have you seen in the meantime?
I haven't seen nobody because they sent me the new doctor that they assigned me was way out on 14 Mile or something, and I didn't need to go to the doctor since then, so I just never been out there.
Well, sir, the court does not accept a marijuana card from a marijuana clinic. The court indicated that the court already indicated what's required.
I told you a doctor, you can't go into your doctor and say, "Hey, doctor, can you write me a letter saying you feel like I need to be on weed?" Doctors don't do that. You
That's
can't
incorrect.
do that.
That's incorrect, sir.
I don't know what doctors you talk to, but they don't do that.
Sir, I'm not.
I asked my doctor before.
I told you what
and that's why I got the card.
Sir.
They don't do that.
Well, you know what? Then we're going to have to hold a hearing on your card and whether or not that doctor's going to come in to see how long
Let's get out of this first, okay?
I'm sorry?
Let's get the let me hire the new lawyer. Let's go get this because we can argue about that later, man.
Well, in the meantime, sir, you're probably going to be coming back for a bond violation.
Yeah, okay. I didn't violate my fine. What you
Sure.
talking about?
Sir, you're using marijuana. That's a violation of your bond conditions right now.
You told
And
me.
once you've been under the jurisdiction of this court, the requirements for medical marijuana are clear.
You know I'm using it for medical reasons. You see my paperwork, Your Honor. Why are you doing this? This is what I'm
For
talking
your
about.
medical reasons, that you would have a doctor that you're treating with that would determine whether or not the medication is appropriate. I'm not going to argue with this any further. If you're testing and you're testing positive for marijuana, then we'll have a bond violation. All right, bonding conditions are continued. Thank you. Have a good day.
Thank you, Your Honor.
Okay, so, let's see here. Is this Tanya Beckley?
Yeah, sure.
Okay. All right, here on the record, the matter of the city of Wyandotte was Tanya Beckley, 25693. And counsel?
Your Honor, good afternoon, John Goldport, P 30758 on behalf of Ms. Beckley. Ms. Beckley, would you please put your name on the record?
Hold on, we have to make sure you're please unmute. You have to hit the hashtag.
Can you hear us, Your Honor?
Yes, sure can.
Okay, we have no picture, unfortunately, so.
Okay, well, I need to see this one please. So, all right, can you tell me your name for the record, please?
Yeah, you're like, wait.
All right, and so counsel?
Your Honor, Ms. Beckley has been charged with possession of drug paraphernalia as well as with the possession of controlled substance. She would waive a formal reading of those charges, stand mute to charges, ask the plea of not guilty be entered.
All right, the court will wait for Maureen. And enter a plea of not guilty for purposes of the arraignment. Settle this matter for a pretrial on May 28th
8:45.
at 8:45 a.m. And counsel has two bonds.
Your Honor, Ms. Beckley is 48 years old. She does have some prior police contacts. There may be an outstanding warrant, but she's not sure of that, Your Honor. She is unemployed. She resides with her friend, and Mr. Lopez, so in any case, she's 48 years old. Your Honor, she's been undergoing some serious mental problems resulting as a result of the death of her daughter, the adult daughter. Your Honor, I discussed this matter with her where she wants to get these matters resolved and she wants to clear up her heroin problem. She clearly has some problems and she needs some help along those lines. We're asking for a personal bond, Your Honor, because we're on unemployment. And she assures me that she will be returning to this court. And if not, personal bond, something commensurate and the charges that have been brought against her.
Okay. Yeah. So, the share is outstanding.
Outstanding.
Ms. Beckley, are you currently on probation?
No.
When I reviewed the report, Your Honor, I did not see any outstanding warrants. However, he indicated when
Right, the difference is police contact.
she was a passenger in the car, Your Honor, in this particular situation. The car was stopped for traffic violations. They were
And if you're to test right now, what's in your system?
Heroin and crack cocaine.
And you want treatment now?
Yes.
And you don't work?
Pardon?
You don't work?
No.
When's the last time you were employed?
I'm sorry.
When is the last time you were employed?
It's been a while. I have some medical issues right now. I just had surgery on my foot, and I have some heart issues. I'm seeking my disability.
And now you're done. Here's the court's going to do. The court's going to order you not to possess or consume any alcohol or drugs unless prescribed. The court's going to order you to be tethered to treatment in the Wayne County Jail. That way, Dan, you get the treatment that you're indicating you would like.
They don't have treatment in Wayne County Jail.
It's not in the Wayne County Jail. It's through the Wayne County Jail. They tell you to a facility outside of the jail.
Okay.
Did you set amount on that?
$10,000 for some time.
Thank you.
Okay, good luck to you, man. We'll see you back next week.
Thank you.
Thank you.
So,
Margaret, the record and the matter of the city of Number 2 Smith, 25121 B Kennedy.
Good afternoon, Your Honor. Your Honor, John Wolford, E3075A on behalf of Mr. Smith. Mr. Smith, would you please put your name on the record?
Martin Smith.
All right, the court's going to continue. It's not guilty plea because you already entered not guilty plea back in January.
That is correct, Your Honor.
You failed to appear on February 10th for a pre-trial.
And Your Honor, I spoke to Mr. Smith. He indicated to me that he posted bond. However, there was an outstanding warrant and there was a hold out in Macomb County. When he posted bond, they took him to the Macomb County facility and he patient violation. And he did his time out there and was in the Macomb County Jail at the time he was supposed to appear back here. He indicated to me, he told them a number of times where he was supposed to be, and Macomb County Jail said, too bad. I mean, that's what he's...
Okay, so has he been in Macomb County Jail since
No, he is not.
today?
No, he is not, John.
Okay, so the court is going to continue as not guilty plea, enter a plea, sentence command for pretrial on May 28th, 10:45 a.m. Mr. Smith, when were you released from Macomb County Jail?
Say it again.
Say that again.
When were you released from the Macomb County Jail?
When was I released? Then it was like what was that, February? The end of February. I said like the 23rd of February. So
So why didn't you come into court? You knew you had a court date in this court. Why didn't you come into court?
I didn't come to court because I was incarcerated at Macomb County Jail.
Sir, we've already established that. And you just indicated that you were released.
I wasn't And when I was released, I didn't have any notoriety or like I didn't have any mail or anything to contact you or anything.
Pause. Sir, do you know how to contact other individuals?
Yes, ma'am.
So it's on you. It is your responsibility to contact the court.
I understand, ma'am.
You were provided all that information. You didn't show up because you were in custody in another jurisdiction. Upon your release, it is your responsibility to reach out and contact the court. Not for the court to find you, try to find you, chase you down, or otherwise. Your responsibility. Don't put it off on the court. You've been out of custody for 3 months. Out of Macomb County Jail custody. How'd you end up in custody today, sir?
You already indicated to me that the officers, based on the outstanding warrant,
What officers?
I'm sorry, Your Honor. There was nothing in the report to indicate that. I mean,
Just a minute. How did you end up in custody today?
They just pulled up on me and hopped out on me, and they said they remember my face and my neck tattoo from the last situation when they called me for the warrant.
Okay.
But it wasn't nothing that I did wrong though. I went to them respectfully and everything, and went into custody.
Okay. And so were you a passenger in a vehicle? Were you driving a vehicle? Were you walking, riding?
No, I was walking from the normal neighborhood store. I was and they rolled past me the first time and saw me, I guess, and they came back around. And by the time I left out the liquor store, they pulled up and they just came and put me in the cuffs and everything. I didn't do anything wrong though, man.
Okay. And so where was that, sir? That was in Minot?
That was on 4th Street off Goddard, like right across from the McDonald's and it's like a car wash right on the end of 4th Street in Goddard.
Okay.
And I was walking with my little brother. That's all. The same situation from before.
Hold on, sir. Where is it you live? Because I show you don't live.
Oh, where I live, I live in a homeless shelter, but I receive my mail at my sister's home. I live in Detroit, Michigan, though.
Okay. So, yeah, okay.
Yeah, I'm not from my.
Do you have any other pending matters, sir?
No, ma'am.
All right. Well, based upon Mr. Smith's previous relationship here, based upon his housing status as unstable due to his homelessness, the court's going
I can't go to my.
Sir, this is
I can't.
The court's also going to note, based upon Mr. Smith's prior failure to appear, failure to contact the court for after he was released from Monroe County Jail, the court's going to order a $7,500 10% bond.
thank you, Your Honor.
In the event bond the GPS held through the Wayne County Jail. You're not to possess or consume any alcohol or drugs unless prescribed.
So I got to certify. So it don't matter that I was already had a bond already. I'm sorry, man. I'm sorry, man. I can report to you from my sister home. Like it's no problem to go to an address that's stable for me to get to. I can go to my sister's home. I just choose not to be at her home. But I can definitely go there if that's any problem. Like I'm not running from you all whatsoever. I completed probation for each point and everything.
Let me just be very clear, sir. You were released from jail in Macomb County 3 months ago. You're here in the city of Minot. You did not turn yourself in. Therefore, the
I
court is
didn't. I didn't have any notoriety about me turning myself in, paying my promise.
Stop. Stop. I'm not arguing with you. I'm just putting forth the reasons why this court entered the bond it just did. Okay? So, you're not possessing and consuming alcohol or drugs that are not prescribed, and the court will see you back on May 28th. Thank you. Have a good day.
So I get
The city of Michigan versus Cunningham, 25692. That's a card.
What's the name, Judge?
Cunningham?
Okay, we're getting them out right now.
Okay, in the meantime, Dr. Carter, do you want to start on the word? Or the plaintiff can work?
Yes, he can.
Sounds great. Good afternoon, Your Honor. Detective Joseph Carwine, PE.
All right, please raise your right hand. You want to swear from testimony about the truth, but you can the truth.
Yes, ma'am.
All right, you may proceed on the word.
Well, Your Honor, on May 18th, 2025, about 4:08 p.m., Officer Syke reported that he and Officers Carpo, Sadowski, and Jones were dispatched to 9337th Street regarding the alleged CSC that just occurred. Officers arrived at the scene and met with the victim, identified as Arias Calhoun and witness Michael Lisi. Officer Syke reported that while Calhoun and Lisi were pouring coolant into her vehicle, an unknown black male, later identified as the defendant, Craig Cunningham, approached them, where he asked them both if they wanted to have some fun. Both Calhoun and Lisi appeared confused, but Cunningham suddenly gripped Calhoun by the shoulders and forced her to the ground. Officer Syke reported that Calhoun stated Cunningham was touching her breast, and while they were on the ground, she could feel Cunningham touching her under her clothing, eventually touching her buttocks area. Officer Syke reported that Calhoun further stated that Calhoun was able to slide his hand underneath her garment and touch her vagina area. Calhoun struggled and fought with the defendant while on the ground for 7 minutes, where he also pulled her hair. Officer Syke added that witness Michael Lisi did witness the entire incident and assisted in pulling Cunningham off of Calhoun. Officer Syke reported that after the initial assault on Calhoun, the defendant left the area on foot, where he was observed entering in a home located at 926 7th Street. Calhoun and Lisi stated they have never met the defendant and do not know who he is, and the assault was unprovoked. Calhoun and Lisi described the defendant as a black male about 40 years old, about 6'2", of 240 pounds, and last seen wearing black t-shirt and light colored shorts. Officer Syke further reported that they checked the area to no avail and soon went to 926 7th Street in hopes to make contact with the defendants. Officer Syke reported that while attempting to make contact with the defendant at 926 7th Street, he observed a black male home matching the same description as previously given. Officer Syke also confirmed the defendant's mail located in a trash can outside the home. Officer Syke recovered written statements from the victim and witness. Later that evening, the night shift officers Alex Stathakis, Morgan Gardaki, John Ames, and Tyler Grove had previously been advised of the incident and attempted to make contact with the defendant at 926 7th Street regarding the assault. Officer Stathakis reported that on May 18, 2025, about 9 p.m., he and assisting officers were dispatched back to 926 7th Street regarding a follow-up for the CSC. Officers were advised that the alleged suspect in the CSC was now outside his home. Officer Stathakis reported that upon arriving at 926 7th Street, the defendant was no longer outside, and they tried to knock on the door in hopes to make contact with him. Again, to no avail. Officer Stathakis reported that he also observed the defendant through a window of the home, where he was seen with two large knives. Officer Stathakis further reported that after several minutes of speaking with the defendant from the home, he refused to come out, but eventually opened the door, where he quickly grabbed his arm.
The defendant attempted to shut the door on Officer Stathakis, where a physical struggle began. Officer Stathakis reported that the defendant headbutted him where they fell to the floor inside the home, where the defendant continued fighting to resist. Officer Gawkan was able to deploy his taser to the defendant, at which time he was subsequently arrested and transferred to the station. Officer Stathakis sustained cuts to both his arms, bruising, swelling, and redness to the right side of his face from being assaulted by the defendant. Officer Gawkan also completed a report 2025-9508 involving a vehicle that was impounded, which belonged to the defendant. During an inventory search of that vehicle, 2 large knives were located in addition to a loaded 9mm handgun.
All right. Upon examination, what is the court does find the offense charge committed and probable cause exists to charge the probable cause to believe the defendant committed those offenses. And Mr. Cunningham, your name for the record, please. I'm sorry, counsel, your appearance, please.
Your Honor, John Goldfall, P. 30758 on behalf of Mr. Cunningham.
And Mr. Cunningham, your name for the record, please.
Greg Cunningham, Your Honor.
Okay. All right. And so, counsel, as to the arraignment.
As to the arraignment, Your Honor, I reviewed the charges filed against Mr. Cunningham. I explained to them each and every one of them. And at this time, he would waive a formal reading of those charges, stand mute to the charges, ask the plea of not guilty to be entered on all charges.
All right, the court will waive the formal reading. Sir, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. In fact, you get an opportunity to speak to one today, correct?
Just briefly, yes, Your Honor.
Okay. I didn't notice the court-appointed attorney paperwork, so
It is in there, I believe.
I didn't see it, but I'll look. The word, once I receive the paperwork for appointed attorney for felony matters, I'm sorry, for appointed attorney for felony matters, the court will sign that. The court also, sir, you have the right to be presumed innocent, shall prove guilty on reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Your Honor.
All right, the court is going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on May 29th. 10 a.m. At 10 a.m. And counsel has you bond.
Your Honor, as to bar, Mr. Cunningham, he is 44 years old. He has no prior criminal record. He reports to me that he is a graduate of Cass Tech. He went to West Point Military Academy and served five and a half years with an honorable discharge. He is presently unemployed. He is from Detroit originally. However, he spent some time in Texas and just returned from Texas. Has lived in the Wyandotte area for approximately 5 or 6 months. He does, however, have additional family throughout the area. As I've indicated, he has no prior criminal record. He is on disability and he suffers from PTSD. There's a number of basis for his disability, and he is presently under therapist treatment for all of those items. We're asking for these very serious charges. However, Your Honor, he does maintain his innocence, has been more than forthright with me. We are asking for a reasonable bond. You were asked something in the area. I understand the circumstances of which would be acceptable under this situation. There are no, as I said, he has no prior criminal record. He was honorably discharged from the service, and he's on disability at this moment.
Okay, Mr. Cunningham, of course, has thank you for the service to our country. And sir, how long have you been in Michigan?
As Your Honor, probably a couple months. I want to say it's March. Not long.
And so, what brought you to Wyandotte from El Paso, Texas?
Your Honor, I had a
friend who's a real estate agent, and he mentioned it was a house available, and I said okay, and it seemed like a decent place and um, time, so just be a place to stay.
Do you have any criminal matters in the state of Texas, sir? Have you ever failed to appear in court for any reason?
No.
Sir, it shows that, and counsel, just for the record, I actually already signed the okay, and for some reason I wasn't clicking the, it wasn't there, but, so sir, on your appointment for attorney, you have indicated that you're married and separated, so which is that? Are you married but separated?
Married but separated, Your Honor.
And how long have you been separated, sir?
More than a year.
How long have you been married?
10, so 15 years.
Are you currently on bond in any other jurisdiction?
There you are.
All right, and detective, as to bond.
Your Honor, taking into consideration the seriousness of the alleged offenses reported by the victim and to protect the community, I would recommend a $25,000 cash bond. I do believe that the defendant does pose some type of flight risk. He does have an address in, from what I can understand, Plano, Texas. I'm not sure if that's his mailing address or what the status of that is, but and then he does have a Michigan driver's license as well. So I do consider that some type of flight risk. So I would ask the court to take those factors into consideration regarding bond.
All right,
Your Honor, we would ask at least the opportunity to post 10% on that bond. I understand the seriousness. I understand that situation, or at least 10% or a surety.
okay.
I think that based on his lack of record, based on no prior involvement with his community, based on his military service and all that he has done, not just for this country, but just in general, showing his reliability.
Well, counsel, the court is taking that into consideration, but the court is also taking into consideration the nature of these charges, these very serious charges. Not only for the named complaining witness in this matter, but also as it relates to the officer that was injured as a result of these allegations. The court is also taking into consideration that the named victim in this matter is a neighbor of the defendants. It appears.
I don't believe so, Your Honor.
Well, let me confirm.
I may have misread that, but there was in the report.
Hold on, counsel. There's also an allegation of random requests people at people's homes. And it does show that Miss Calhoun resides on the same street, which I believe is probably across the street from your client based on the addresses. And so
That would be correct. It appears that the defendant does live directly across the street from the victim. And as far as the other party involved, there was no charges in those allegations, but there is some pretty good evidence indicating that that did happen. Although no charges were filed regarding that incident.
there's a ring camera or something. I don't know. However, I understand, but taking all of that into consideration, and the court has to take into account that the allegations in this matter are that it was completely unprovoked. The parties don't even know each other. And these are the allegations that are put forward. Court is going to order the following. The court is going to, for the protection of the victim and the public in this matter at large, the court's going to order a $250,000 cash jury 10% bond. In the is to be no contact with Ms. Calhoun. That's phone contact, text message, email, social media, third party, anything of the like. There's not to be any contact with any prosecution witnesses. You're not to the premises and the home on 7th Street. And in fact, the court's going to order that you're not to enter the premises in that block on 7th Street at all.
Can you repeat that, Your Honor?
You're not to enter the block of the 900 block of 7th Street, with the exception of one visit to obtain your personal belongings as long as you're accompanied by a police officer. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those in your home, sir?
There are a few things I have in the home, Your Honor.
Weapons or firearms?
Yes, Your Honor.
All right, those should be turned over to the Whiteout Police Department for safekeeping. And you are not to be released by GPS up into the Wayne County Jail. So, sir, solid substances, if the event bond is posted, you are not to return to your home unless you have an officer accompanying you for the purpose of retrieving some personal items that you may need for your everyday living. We'll see you back on the 29th. All right, and we are. I'm sorry.
Something you said after it was kind of echoing. I couldn't hear you clearly.
I said we'll see you on May 29th.
Good luck.
Okay, thank you, Your Honor.
Canoli 25691. And counsel, detective, your is this detective? Oh, this is detective.
What's that, Your Honor?
Okay, she can get a call. I know it's be home in 15 minutes.
Yeah. He said first call.
Whoever you're going at your house.
Oh my God. So a plumber.
No.
And you're supposed to be there now, but the hotel, my father.
Sit right down in that chair.
Okay. So we are on the record in the matter of David Canoli. And so, Detective, your name for the record, please.
Detective Steve Sable, Your Honor.
All right, please raise your right hand. Do you solemnly swear from testimony about to give this to be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You proceed on the word.
Thank you, Judge. On 5/17 of this year, at approximately 9 p.m., Officer Ames was dispatched to 264 Superior Street, apartment number 1, for a domestic assault where the offender had taken the victim's vehicle, which is a 2011 Chrysler 200, bearing Michigan license plate Edward Mary Sam 686. The Chrysler 200 is gray in color, and he took it without permission. While en route to the scene, Officer Gardaki had informed over the radio that Officer Tyler Grote and Officer Alex Stathakis had initiated a traffic stop on the suspect at 3rd Street and Ford Avenue. The complainant, Kimberly LaRose, stated that when she was assaulted by her boyfriend, the defendant, officers observed LaRose to have a large bump on the left side of her head near her hairline. LaRose was visibly shaken to the officers. After an evening out, LaRose reports that she returned home to 264 Superior, apartment 1. The defendant began yelling at LaRose and accusing her of cheating on him. The defendant also stated that LaRose was not at the birthday party and that she was lying. The defendant left the residence and took LaRose's vehicle to the dollar store. When the defendant returned back again to the address, he began again accusing LaRose of cheating. While the couple was arguing in the room between the kitchen and living room, the defendant began to punch LaRose in the face with a closed fist approximately 2 to 3 times, causing LaRose to fall on the floor. LaRose decided that she was going to leave with her 12-year-old son. While LaRose was speaking with her son to get his belongings, the defendant took LaRose's cell phone and her wallet and ran out of the house. The defendant then took LaRose's car, the 2015 the Chrysler 200, bearing a Michigan license plate Adam Paul Frank 835. This is a 2015 vehicle. LaRose stated that Conley did not have permission to take her vehicle like she had before when he went to the store. LaRose said that the defendant was only allowed to take it to the store, and that was already a completed act. LaRose stated that she and the defendant had been in a relationship for approximately 6 years, and that the relationship has been on and off. While responding to the call, Officer Gardaki and Stathakis observed LaRose's vehicle near Walnut and 3rd Street, enter the southbound lane of 3rd Street, and pass another vehicle at a high rate of speed, which was well above the posted 25-mile-an-hour speed limit zone. Officers turned onto 3rd Street and activated their overhead emergency equipment and lighting in an attempt to catch up to the vehicle. Officers were able to catch up to the vehicle and the defendant who was driving it at 3rd Street and Ford Avenue. The defendant admitted to the officers to leaving the scene after that argument with LaRose. The defendant admitted that he did not have a valid driver's license. The officers confirmed via a lean check of the Law Enforcement Information Network that, in fact, the defendant did not have a valid license. And he also had the victim, LaRose's phone, with him on his person, and the victim's wallet was located in the front passenger seat of her car. Thank you, Your Honor.
All right, thank you. Upon examination of the plaintiff witness, I find the offense charges committed as probable cause of the defendant committed the offense. And counsel, your hands, please.
Your Honor, John Goldport, P 30758 on behalf of Mr. Canoli. Mr. Canoli, would you please put your name on the record?
David Canoli.
All right, thank you. I feel as though you've been here before, sir. Have you?
Yes, I have.
Okay, well, that's an unusual name, so that pretty much stuck with me. All right, and so, counsel, as to the arraignment,
As to your Your Honor, he'd stand mute to the charges, waive a formal reading of those charges, ask that the plea of not guilty be entered.
the court will read the formal reading, enter a plea of not guilty for purpose of the arraignment. So you do have the right to have an attorney. If you cannot afford one, the court will, you can have one appointed to represent you. And in fact, you got an opportunity to speak to an attorney today. Is that correct?
Correct.
All right, the court has also signed the attorney for appointed attorney matters for felony purposes. And as to the balance of your rights, so you have the right to be presumed innocent, to proven guilty beyond a reasonable doubt. You have the right to the trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing against the court. Do you understand those rights?
Yes.
The court's entering a plea of not guilty, as I've already indicated on your behalf. Scheduling this matter for probable cause conference on May 29th. 9:45. At 9:45 a.m. As to bond counsel.
Your Honor, as to bond, Mr. Canoli is presently on parole for home evasion. He has been on parole for approximately 6 months. He is unemployed at this point in time. He resides at a halfway house located at 15430 Lauder Street in Detroit. He does not live with the victim at this point in time, though there has been a relationship.
I'm sorry, what's the address?
Right? He lives in a halfway house at 15430 Lauder Street in Detroit.
Interesting, because the part of paperwork we filled out put a completely different address on Superior. Not even the one where the offense occurred is alleged to have occurred.
Well,
So interesting.
where do you live? Pardon?
It's what's on my ID is 10 Superior Boulevard. That's my mom's residence. That's where my mother lives.
When I asked for what's on their ID, it's where can you be found? All right, go ahead, counsel. Sorry.
There is that. As an indicated, obviously, he does have some involvement with the justice system. We're asking for obviously a bond which is reasonable in these circumstances when that he can be expected to make, so that he can contest these allegations along with that situation. So I believe that because of the parole, he's not going anywhere. That's for sure. There's not a parole hold, as far as I know. He has been in contact with his parole officer, but not since this, and everything seems to be going smoothly. We're asking for a bond that he can make, as I indicated. He's unemployed at this point in time, and he's living at this halfway house, getting through his the remainder of his parole, which is approximately a year and a half.
So, sir, why aren't you employed?
I'm in a working program right now, Chance for Life.
So in other words, at this halfway house, you're also going through job training?
Yes, that's what I just started maybe like a month ago. I'm in job training right now.
And sir, the matter in Calhoun County, who is the named victim in that matter?
I'm sorry, excuse me?
The matter in Calhoun County, second offense domestic violence. Who is the complaining witness or the victim in that matter?
In Calhoun County?
Valerie?
The incident that happened last time, or it was with Kimberly Rose?
Okay, we still miss the rose. Okay, and the home invasion that you're on parole for.
Yes.
Whose home was that?
I'm not sure. I don't know the person's name, or I didn't know the victim.
Okay. And so interestingly enough, that was in 2016. And then in 2021 is when you were charged with domestic violence second offense. And so were you paroled? And then you had a parole violation, you were back in custody and you were re-paroled?
Yes.
There we go. Well, it shows on here that he was sentenced to 3 to 15 years in 2016, and the matter in Calhoun County occurred in 2021. So that, and then he just has been paroled 6 months ago. So I was confused as to how something happened in 21 if he was out in custody, but he was not in custody. And so, sir, were you back in custody as a result? It was a parole violation?
Yes.
And are you not required to have employment, sir? As a,
Yes, ma'am. Yes, I am. Yes.
And sir, you don't have a valid license.
No, I don't.
Somehow you ended up here from the home in Detroit. Detective asked you bond.
I think it's more than reasonable, Your Honor. $25,000 cash for the UTA, for the bond, domestic, etc. No operator's license. No contact with the victim or the family of the victim and/or witnesses in this matter, please. Not to return to the address of 264 Superior Boulevard, apartment number 1, and not to drive unless valid license in possession. Thank you, Judge.
You and Mr. Rose have any children in common? So 0 reason to have contact with her. Given the defendant's current parole status, that he's violated parole before, given the nature of these charges and the concern this court has for the safety of the public and Mr. Rose, and for the defendant's inability to, it appears, follow the laws and the rules surrounding his parole, the court is going to order a $500,000 cash, 10% bond, no surety, with the following bond conditions. You're not to have any contact with Kimberly LaRose or any family members of Kimberly LaRose. That's phone contact, text message, email, social media, third party, anything of the like. Do not attempt to contact her from being in custody. You're not to have any contact with prosecution witnesses. You're not to return to her home on Superior Street. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those, sir?
No.
You are to not operate a motor vehicle without a valid license, and in the event you post bond, you're not to be released without a Wayne County Jail tether, house arrest. Any questions?
No, Your Honor.
We'll see you back May 29th. Let's go all your five seconds. Let's go. Just for a moment.
Okay.
All right. And then let's go on the record in the matter of the state of Michigan versus Ariel Keenan, 25370.
Afternoon, Your Honor. William Winters, P35975 on behalf of Ms. Keenan.
Thank you. And Ms. Keenan, your name for the record, please. Ariel Keenan. I need you to speak up, please. I'm recording on here, so I need to be able to hear you. Ariel Keenan. Okay. And so today's date scheduled for sentencing on your client's plea to an amended charge of controlled substance use. The original felony of possession of controlled substance was dismissed by way of resolution by counsel at the probable cause conference. And counsel, did you have an opportunity to review the report recommendation with your client?
Yes, Your Honor. And we have no additions or corrections to make with regard to the pre-sentence report itself, but the recommendation we'd like to speak to.
All right, and counsel?
You know, I think Ariel Keenan recognizes that she's got a substance abuse issue, and she's already been in treatment at least once. And you'll notice that she's trying desperately to try to get her children back, and she's really on the final path to try to make that happen. And you can see that she's a high school graduate and that she's got a good job at Five Guys. And part of this treatment that she's been involved in has been paid through either insurance or third-party insurance. She also has, you might know, that she's got a case pending downtown, 5301 Russell Street. And we're in the process of negotiating a settlement in that case that will keep this young lady out and treating and in a position to try to get her family back together. So the court has several options, obviously. Because it is use, she accepted responsibility for Your Honor. And that's always the first step toward rehabilitation. You know, from a financial point of view, she really doesn't have a whole lot of assets or resources. Other than, you know, she's got a job that she maintains. So I respectfully ask the court to either consider perhaps placing her on 7411 status or delaying this sentence for about 6 months, 9 months to see how she does. And then the court's certainly free to take whatever actions the court feels appropriate.
Well, counsel, 7411 doesn't appear to have ever been on the table in this matter. However, Ms. Keenan, are you interested in drug treatment court?
Yeah.
Have you explored that at all? Have you spoken about it with your attorney at all?
No, I don't know what that is. I know that from my understanding from what you just said, it's something about dropping, which I do twice a week.
Oh no, it's much more than dropping.
Okay.
What it is it's a much more intensive oversight probation, specifically for individuals with addiction issues.
Okay.
So you meet a lot more directly with the judge.
Okay.
And there's also the option based upon the report here, you may be eligible for treatment that we have here. We have a regional wellness and recovery court, so it's a mental health court. And so there are some individuals that are dual treatment. And so we handle both the addiction and the mental health portion of that. So if that's something that you're interested in, we can adjourn the sentencing so that you can determine whether or not you are eligible, and in addition to that, whether or not that's something that you are interested in doing.
I think it's an excellent suggestion, Your Honor. And I ask respectfully that you allow counsel and Ms. Keenan to investigate, especially because there's a mental health aspect, particularly timely, that marches Mental Health Awareness Month.
May, but you're correct.
Or May, right? Yeah.
I did the same thing.
They'll be nice. So yes, Your Honor, we'd ask that you consider setting this over.
Okay. So let's adjourn this. Let's adjourn this to June 10th. That's 3 weeks. That should be sufficient time for eligibility screening. So you'll do a criminogenic and then a clinical screening. So what I'm going to do is I'm going to, for right now, adjourn it to June 10th. We'll do 1 p.m. If that's not enough time, then it will be rescheduled. All right, I'm going to order bond and conditions are continued. And then we will see you back down. We have you go over to probation.
Okay.
And they will get in contact with Courtney, who is our coordinator and probation officer for the program. Okay?
Yep.
All right. So just have a seat open probation. Somebody will be with you shortly.
Thank you very much, John.
All right. Thank you. Have a good day.
Give me Rufus Watson versus DoorDash.
That's me, right to the podium. All right.
2501347.
Good morning, Your Honor.
Good morning. Your name?
Rufus Watson.
Is anybody here for DoorDash?
No, Your Honor, I've not had anyone check in.
Do we have?
It was served by certified mail. I believe a copy of the signature card is attached to your packet.
Looks like Uvalde or Uvalde. I'm not going to swear you in yet. Just tell me what happened.
On March 18th this year, I received a deposit from DoorDash of $88.18. On March 21st of this year, there was a reversal of what my bank had sent the money back because they thought it was fraud, but it wasn't fraud. It was a mistake on my bank end. I reached out to DoorDash and let them know the hiccup that my bank had made and sent the money back to them. And all they keep telling me was, where we paid you on March 17th.
You work for DoorDash or something?
Yes, Your Honor.
So you worked for DoorDash, you were DoorDashing, they gave you money, and then somehow the bank reversed it?
Correct, Your Honor.
Have you called them?
I called the bank. When I called the bank said, and when I communicated with them, they said there was nothing that they could do about it because the money has left their account. I had to communicate with DoorDash. So I called DoorDash and they just say, we already paid you. They're not paying the money that they.
And that's for how much?
$88.18.
Why do you have $116.17 it looks like circled over here?
$12 for the.
I see, the court costs?
And then there's also the $4 for the ATM fee. Because yes, court costs, court fees, all.
What was the $4 ATM fee? What do you mean $4 ATM fee?
I had to withdraw from the ATM that's in the hallway out here.
Yeah, I can't really give you that. Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be to hold yourself you got.
I affirm.
Okay. Why did you need to take the money out of the court ATM? I'm not sure. Is that to file the complaint?
Yes, I had to pay $12 and then I had to use the ATM machine because for the thing, so it was $16.
I can't give you that.
It was a total cost of $16.
I know. I just can't give you that. So the total amount that they owe you is $88.18. I can give you the 12. For your filing fee. So unless I'm missing something, this should come to $100.18. Is that right?
Yes. Correct.
It seems like this could have been handled. You called them and they just said, we're not paying you?
I have sent multiple emails. I have sent multiple chats. I have called them multiple times. They just keep saying, we already paid you. No.
Well, they didn't do anything. They didn't show up. They could have. At any rate, I'm going to go ahead and I'm going to give you the judgment. Default judgment. Defendant failed to appear. It seems strange that you're suing you deal with the San Francisco, California company as opposed to a local company here?
I do not understand your question.
Well, you're suing DoorDash in San Francisco,
Mhm.
right?
Yes,
Isn't there like a local DoorDash regional office or something here or not?
it's a app that you download on your phone. So I had to look up their headquarters and send it out to them. There's no one that, no faces, no offices or anything.
In Michigan?
Not that I'm tracking, Your Honor.
Okay, all right, good enough. They didn't answer, so I'm not gonna question it. I'll give you that judgment. I filled it out. I wish you well. You can go down the hall. They'll give you a copy of the judgment. That judgment's entered by default. Thanks. Good luck.
Thank you, Your Honor.
Have a good day.
Where do I pick up the,
You can go right down to the civil department. He'll bring the file down and they'll give you a copy of the judgment.
thank you.
Have a good day. Hey, you walked in here looking like a lawyer, and that's a good thing. Too many people come in looking like they're going to a ball game or something.
I appreciate that, Your Honor.
Have a good day.
Thank you.
All right. I don't need them out unless they're ready on that. I'm gonna call.
They are out, Judge.
All right, let me take you, Ms. Kingsley. First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Good morning, Ms. Kingsley.
Good morning, Your Honor. Brianna Kingsley appearing on behalf of the plaintiff.
All right, where are the other two? Rice and Shearer.
Here, he just needs to unmute and turn his video on.
Oh, there you are, Mr. Rice, bottom corner. Can you unmute and start your video, please, Mr. Rice? And then I'll need Mr. Shearer in here.
Mr. Shearer is not here.
So he's going into default.
Mm-hmm. And Mr. Bryce and I have an agreement to
Mr.
place.
Rice, you got to start your video, sir, and state your name, please. I love Zoom. I mean, I really don't mind it until I feel like, I don't know. I don't know what to say. I mean, I don't mind it, but then I get this kind of nonsense. Like, where's he at? He should, can you chat with him, Jen? Mr. Rice, I need you to, there you go. Okay. Now, that's all right. You're fine. Now unmute in the bottom left-hand corner of your screen, please. Your name. Okay, so I'm going to call the case against First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Mr. Rice, your name.
Robert Curdington Rice, Jr.
All right, Ms. Kingsley.
Brianna Kingsley for the plaintiff. So,
And,
Your Honor.
Go ahead.
So, Your Honor, this is an action for claim and delivery for a manufactured home that is currently in default. So, Mr. Shearer no longer lives in the home and evidently lives somewhere in Maryland, unsure of his exact location. We've gone through the appropriate methods to obtain alternate service and had submitted a request for a default, and then the court had set this for hearing on entry of the judgment. So Mr. Rice and I have actually come to a resolution today, and I've spoken with my client. We're going to enter into a consent order for possession of the home. Mr. Rice, so this will enter by default as to Mr. Shearer. This will be consent as to Mr. Rice. So they can retain possession of the manufactured home so long as the past due, the accelerated balance of $58,422.34 is satisfied on or before May 30th of this year. If it's not paid in full by that date, then my client may submit an affidavit of noncompliance and a proposed judgment for possession. Mr. Rice and I have already gone through everything. He indicated that he was approved for a loan through Rocket Mortgage and intends to have the entire accelerated balance paid, and thereafter the loan would be satisfied.
Okay, so.
But I know that's a lot, Judge.
Oh, that's not 58,422.34. You're sure you're going to have that, sir?
I believe so. This is what my daughter tells me. She's the one taking care of this for me.
Well, okay, so
I was told,
hang on.
I was told that this would
hang on. So you want to submit a consent order of dismissal that says consent order of possession that says that he's going to pay 58,422.34 on or before the 30th. It's going to be a default as to sure. If he does that, then he obviously retains the property. If not, your client is going to submit an affidavit of non-compliance and take ownership. True?
Correct.
Do you understand and agree to those terms, Mr. Rice?
Yes, sir.
Well, I want to make sure you can pay it. You positive you're going to have the loan go through in the next 11 days? I mean, we have Memorial Day coming up and everything.
That's what I was trying to explain to you a moment ago. It should be done by the 27th, but it could be done by the end of the week.
Listen, why don't you give him another week or so, will you, please? Tell him the judge wants you to give him another week. June 10th. Can we make it June 10th?
Can I call my client? It would have to be an updated accelerated amount as of that date. So I would just have to get the new balance because as it continues, I mean, late fees are going to continue to accrue.
Why don't you wait right there, Mr. Rice? Why don't you wait right there? But if he does June 10th and he pays by May 30, you still only have to pay the 58,422.34. You can put that in the judgment, right?
Correct. Yeah. Let me just call my client really quick to get the
All right,
updated.
I'll go on to another case. Just stay right there, sir. I just don't want you to lose it because something weird happens and you don't get the loan out, right?
Yeah, and now I mentioned this tablet.
I got it.
And me losing you.
All right, give me Cornell and Plumbing, Edwards Plumbing. Do we have that file here?
Right to the podium here.
I need the file first, so wait 1 second. Virginia Swindle versus Tracy Lynville. Nobody appeared on this. This was a show cause scheduled. Nobody appeared. I'm going to go ahead and just reschedule the show cause, Jennifer. Ms. Swindle has a hard time getting here. So let's reschedule the show cause and give her another date. Put it out about 3 weeks. Will you do that for me, please?
No problem.
All right, now. Robin Cornell versus Edwards Plumbing and Heating, Inc., 2404088.
Yeah, are you part of this? Yeah. Right to the podium.
Well, she doesn't need to be, just the lawyers.
Is she good, Your Honor, sit there?
Yeah. Mr. Gutner, your appearance?
Good morning, Your Honor. Patrick Gutner, P70106, appearing on behalf of the plaintiff, Robin Cornell.
Mr. Kavanaugh?
Good morning, Your Honor. Philip Kavanaugh, appearing on behalf of defendant Edwards Plumbing, 59404.
All right.
I believe, Your Honor, that we have reached a settlement.
Okay.
Put that on the record.
Perfect. Go ahead.
Your Honor, may it please the court, and we'll have defendant's counsel Purcell at the end of the day. We've agreed to settle the matter in its entirety for the sum amount of $12,000 payable within 30 days from the defendant to the plaintiff through my office.
And a release will be executed, release of all claims by either party or just the plaintiff?
By the party.
All right, you agree to that, Mr. Kavanaugh?
We do.
Why don't you come on up here, Ms. Cornell? All right, so no question but that the defendant can pay that within 30 days?
I believe, yes, 30 days is fine.
Ms. Cornell, come on up here, tell me your name.
Cornell.
Do you understand what your lawyer just said? You got to keep your voice up for me, okay? Your lawyer just told me that he's settling this case and you agree to settle the case for $12,000. That would be a full and final settlement of this claim. You would be releasing any and all claims arising out of this event, transaction, or occurrence for all time against Edwards Plumbing in exchange for this agreement. Do you understand that?
Yes.
So you understand you can't go back and sue them for any reason arising out of this claim that you have as set forth in your complaint?
Yes.
You could go to trial. You might get more, you might get less, you might get nothing. Do you understand that?
Yes.
But knowing all that, you wish to settle for this amount?
Yes.
And you're authorizing this claim on behalf of this resolution on behalf of your client, right, Mr. Kavanaugh? All right, good enough. Submit your paperwork. Is this gonna be in the form of a, just a stip in order to dismiss, or are you guys doing it by way of a judgment?
I'd like a judgment, Your Honor.
Yeah, and so you're gonna enter into a judgment for
Yes.
12,000, correct, counsel?
Yes.
All right, you guys submit that judgment, hopefully in the next couple days. And I'll sign it, we'll be done with it, okay?
Your Honor, appreciate your time.
Thank you both, have a good day. And good luck, ma'am.
Judge, I don't know if this matters, but she just showed up.
Oh, jeez. Where is she?
She's right here.
Why are you showing up late?
I couldn't get out of work, Your Honor.
You can't do this.
It's happened so many times.
You can't do that. All right, I got it. Just wait 1 second. All right, Ms. Kingsley, did you get a chance to talk to your client yet?
Did Judge, they're fine with the June 10th date.
Let me call the case. First
I just
choice,
have to add up
first
the
choice.
numbers really
Wait.
quick.
First choice, MH LLC versus Marshall Shearer and Robert Rice, 2403493. Mr. Rice, your name again?
Robert Crittington Rice Jr.
All right, Ms. Kingsley?
Brianna Kingsley for the plaintiff.
All right, so did you get an extension for Mr. Rice here?
Yes, I did, Judge. I'm just adding up the final numbers with the legal fees and late fees. So the accelerated balance alone on the loan is $58,422.34. And then there's legal fees of $2,330.30 so far. And then I'm just waiting on one more invoice for an additional legal fee that I need to add in.
So the agreement between the plaintiff and the defendant calls for attorney fees, does it?
Yes, these are attorney's fees that have accrued during the pendency of this case that my client is entitled to reimbursement for.
Yes, per the agreement that was reached. Let me just double check. Not that I would ever think that you would ever ask me for something that you're not entitled to, but I do want to check on attorney fees here. What page of the agreement is it on? Can you tell me?
Yeah, let me look at the purchase agreement really quick. Let me pull it up. Here it is. Okay, it is of charges.
Well, I'm just paging through it. I don't see anything that's entitled attorney fees.
Just give me 1 second, Judge. I'm going through the purchase agreement. It's always on the
I hope you're not gonna. If lender elects to accelerate this note, lender may require borrower to pay all costs and expenses during the enforcement of this note and those incurred during the recovery, restoration, and liquidation of any collateral specified in this or any attendant collateral attachment agreement to the extent not prohibited. That doesn't specify strong enough for me that they're required to pay attorney fees. I don't see anything. I'll tell you what, I'm going to go on to another case here, okay?
Yeah, can we just pass this matter for just one moment?
Stay right with us, Mr. Rice, okay?
Okay. Yes, sir.
Virginia Ann Swindle versus Tracy Lynn Lynville. 2402676. Your name?
Tracy Lynville.
Boy, between you two, I feel like this case has been going on since I was a kid.
I know, right?
And that's not true, but I mean, it's been going on for a small claims case.
Yes.
So you didn't appear for creditor's exam on April 21. You can't miss these. That's a subpoena. That's an order of the court, ma'am.
I'm sorry. I missed so many
I
days
want you
from
to,
work.
I
that
know,
just started.
well, I get it, but you cannot miss court. I mean, I could hold you, listen to me, listen. When'd you get the job?
Just before court started. When did we start coming?
I know, but you can't ignore a subpoena. Are you kidding?
I didn't even know it was a subpoena. I'm sorry. It was just a court date.
And now she's not here.
She's never here.
Well, no, she's been here a lot more than you have lately. Where do you work at and what days?
I work at Novellis Lab.
What days?
I work midnights, weekdays, 7 for 5 days a week.
Well, tell me what you work, what hours?
I work midnights.
I know, but what hours? 11 to 7?
No, 11 or 12 to 8.
Okay, so why can't you get here? You're making it sound, oh, wait a minute.
Sorry.
You're making it sound like you can't get here because you can't take off of work. Wait a minute. We don't conduct court at 1 o'clock in the morning or 3 o'clock in the morning. I just don't want to hear that.
I understand.
You cannot ignore subpoenas. I don't get this society of ours. We don't think court orders mean anything anymore. I'm rescheduling the show cause. I'll set it for later in the morning for you. Don't miss.
I appreciate that.
What time were you supposed to be here this morning?
I couldn't find my paperwork.
8:30. 8:30. If you walk in at 10:10.
I'm sorry.
I just want to know what everybody would think of me if I scheduled cases at 8:30 and showed up at 10:10. You know what they would think? I wouldn't blame them. I'm going to reschedule this show cause. I'm going to set it later in the morning. I expect you to be here. You better bring all your papers for the credit that you were supposed to bring for the creditor's exam. Do you understand? Jennifer, I want you to give her the subpoena, a copy of the subpoena.
Okay.
And you're gonna bring all those papers to the show cause with you, okay? We're gonna give you a date right now, so it doesn't get lost in the mail or the dog eat it or anything else, all right?
Sure. I never got those full paper.
Jennifer, give me the date, please.
June 17th at 10 a.m.
June 17th at 10 a.m. I don't believe my packet has the subpoena. I trust you do.
Yes, I do, Your Honor. I'm
But she's
printing it
gonna
right
give
now.
to you. And you have to bring tax returns. It's gonna spell it out. I expect you to bring everything, so you better get started on that, okay? June 17th. You got it?
Yes, thank you.
You're gonna go down the hall and get your date. Send it out to Ms. Swindle again. June 17th at 10 a.m. Good luck.
Thank you.
John and Aaron Purcell, is anybody here on that? Versus Gawkan and Sons Towing, 2404841.
Good morning, Your Honor.
Your name?
Michael Scott.
Where's the plaintiffs, Lisa? Are they here?
Judge, I've not heard anything from them. Let me see if we can reach out to them really quick, only because there was, this was given to Dino, and I just want to make sure they got the correct date.
Yeah, they're supposed to be here at 9:45. It's 10:17 or thereabouts.
Am I allowed to move for dismissal?
I'm gonna dismiss it if I don't get a real good explanation. They're probably gonna file a motion to set aside the dismissal. Welcome to my world. Court dates now, they're not about as important as whether or not somebody cuts their lawn. I mean, I don't get it. They sue you and then they don't show up.
Yeah, in my business, I see it all the time.
Well, it's ridiculous. I don't know that we need to send him this is the plaintiffs.
Right. On the defense.
Jen,
Yes, Your Honor. I know there was some confusion because we sent certifieds that were unclaimed to Gotch & Sons. So then the personal service went out, and I just want to make sure that he had the correct date with changing of the dates. This is not the initial date that was ever set on this.
so
We
you
started
call,
trying to serve. Yeah, we're reaching out to him right now. We started trying to serve this for a court date in February.
sir, why don't you have a seat? I'll be with you in a second, okay?
Yes, sir.
Judge, can I just have one more minute?
Yeah, take your time. I'm waiting. I'm calling another case. I've got another case going. Take your time.
Okay, thank you, Judge.
No problem.
Judge,
Yes.
okay, my client's gonna agree to do the consent for the 58,422.34.
Wait a second. Wait, I gotta go back and call it. Is that what you want?
Yes, please, I'm ready.
First choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Everybody's name?
Brianna Kingsley for the plaintiff.
Sir, your name? Mr. Rice, I need your name, sir.
Robert Cunningham Rice Jr.
All right.
All right,
So-
Judge. So we've agreed to enter into a consent order for possession of the manufactured home. The final accelerated balance due on the loan is $58,422.34. And my client has agreed to give Mr. Rice until June 10th, 2025 to have that paid.
Okay, now this does not include attorney fees because I was right?
This well,
John, you have to take off your hat.
Oh, I'm sorry. Good morning. I just making sure, just getting logged in here.
hold on one second. I grabbed the wrong
You just muted again.
I grabbed the wrong document. I'll be right back.
Okay.
Sorry, Judge.
We're so nice, this would be disturbing, but go ahead. Go ahead, take your time. Jeez. All right. Let's do this. John and Aaron Purcell versus Gawkan Sons Towing, 2404841. Sir, your name?
My name is John Purcell.
Where's Aaron? Is she with you?
No, she is at work. As I was explaining to your secretary, Your Honor, is that I didn't get the second notice of the rescheduling for today, May the 20th. I did get a notice and a telephone call in regards to having to reschedule the last time, as well as Gotch's and Sons and was not picking up their mail, so I had to hire a private.
But I don't need to hear a big long explanation. I just wanted to know if she was here. Why did you list her? Who owns the vehicle?
Who owns the vehicle? It is it's my wife and my father-in-law that's on the title.
She should be here. Jeez. You can't get a hold of her?
No, she is a branch manager of a bank. So usually throughout the day, I don't speak with her until about 1 p.m.
Well, I'm going to need to reschedule then. You can't really stand in here. You don't own the vehicle. Right?
Okay.
This was her vehicle that she owns and your father-in-law owns that was towed, right?
That's correct. And it's the bill is in her name, it says on here.
Yeah, so if it's her name, she's going to have to be the one. Did you tow the vehicle? Your name?
My name is Michael Gotch.
I just want to try and see if I can help people resolve this or understand it.
Here's where
I have a question and concern. We're in small claims, and this car was removed because it was abandoned on private property, and it was requested to be removed by the property owner. So MCL 257.252A allows for that to happen, and the only and sole remedy in a case about an abandoned vehicle is to have a hearing that needs to be within 20 days of the incident. This has far exceeded 20 days. And therefore,
it was back in December of 24, right?
Right. And it clearly states in the statute that that is the sole remedy for an abandoned car case. So even if they're not.
I'm very uncomfortable taking care of this now with the proper plaintiff not being here, since the proper plaintiff didn't receive notice. So here's what I'm gonna do. Sir, I want you to write that statute down. Maybe you can talk to a lawyer, Mr. Purcell.
Okay, Your Honor, I just want to say something though.
Hang on, no, please,
Okay.
just write the statute down. MCL 257.252A.
I got MCL 250.72.
Oh, no. MCL 257.252A. MCL 257.252A. You might want to have your wife talk to a lawyer.
We did, Your Honor.
Hang on a second. I cannot go on this without your wife being here. We didn't give her proper notice. I'm going to adjourn the case out. Sir, you can appear by Zoom. I know. I'd rather that everybody appear in person, but you came here. It's not your fault. Do you have a lot of documents for me to look at or anything? You got a big notebook there.
Well, because
I just want to know if you have a lot of documents. I might tell you have to come if you're going to bring in, if you're going to scan 87 documents and they have to bring them to me.
yeah, I'll come in person.
All right, let's adjourn this, Jen. Give me a date about 3 weeks out.
June 3rd,
What time?
9:30.
So I'll just say plaintiff did not have notice. Real party in interest is the wife. Real party in interest is the wife. So you're not going to be able to talk about this, sir, is Aaron Purcell. Okay? I don't know anything about it. I'd like to that's it. Okay? I'm sorry, everybody. And again, if you don't have a ton of documents you have to have scanned, I mean, I can't imagine what you got in that notebook.
I have a lot of photos, and there's a lot to this abandoned car removal. I could go on and on. The wrong parties being served, there's a whole laundry list of things here that's not proper and going on with abandoned car removal. It shouldn't be in small claims.
Right. You better, why don't you talk to a lawyer, Mr. Purcell, please?
We already have, Your Honor.
Okay, good enough. I'll see you guys.
That's why we're coming here.
Thank you very much. Thanks.
Thanks.
First Choice versus Marshall Shearer and Robert Rice, 2403493. Ms. Kingsley, your name.
Brianna Kingsley for the plaintiff again.
All right. Mr. Rice.
Yes, sir.
Your name.
Robert Crittenden Rice Jr.
Now you can go ahead and tell me what the deal is.
Thank you, Judge. Okay. After I removed all of the legal fees, the total payoff amount that is due by June 10th, 2025 is $56,092.04. While I do understand the court's position that paragraph 9F of the purchase agreement is not sufficient, we do disagree with that, and I would just like to note that for the record.
Yeah, I get it, but you know, to me, if you're going to start collecting attorney fees, it better be It better be abundantly clear, and it doesn't say one, it doesn't even mention the word attorney fees. It does say costs. Let me just double check.
Yes, it does reference costs. I believe it says costs and
Expenses.
yeah,
And
costs
that
and
isn't
expenses.
good enough for me to have me give you attorney fees. They have to be specifically spelled out as far as I'm concerned. So, sir, you saved a couple of $1,000 and you're gonna get till June 10th, but don't play with this. If you get the money today, pay it tomorrow. You with me?
Yes, sir.
All right, so that'll be a default versus sure by consent. You understand everything and agree to everything here, Mr. Rice?
I sure hope so.
Well, you have to pay 5609204 by June the 10th. If you don't, they're going to submit an affidavit of non-compliance and they're going to get the home. Do you understand that?
Yes, sir.
And you're sure you're going to be able to pay this, right?
According to my daughter, she's helping with this situation through Rocket Mortgage. See, Your Honor, I come into this with an 815 credit score before I signed for this loan, and I'm down to 635.
What happened?
I signed for this loan and they're not paying it. My daughter can't because Marshall left. Marshall Shearer left.
I see. You co-signed.
Yes, sir. That was a big mistake. I'm trying to help people, and this is what I get.
I know. I get it. Yeah, it's not a good idea to co-sign. I know we want to help our family, but sometimes some people tend to get with the wrong people in relationships. They're not very, let's call them responsible.
This is her stepfather, Marshall Shearer.
Okay, well, I don't
Of
know.
all things,
Anyway,
here
that's up.
I'm signing for a loan for my ex-wife's husband because he died.
Well, you're a good man. You're going to be taken to the right, you're going to go to the right place, sir. I don't know what to tell you. And I mean that. I mean that.
Thank you. That means a lot.
What's that?
Thank you. That means a lot.
I really wish you well, sir. Good luck. Just make sure you pay that and then you got the home. Good luck.
Thank you. Have a great day.
One final question,
Sure.
Mr. Wright. Do I have
Yes.
permission to sign your name to the proposed agreement and e-file it with the court?
Yes.
Okay. All right. I will get that drafted and filed with the court.
Thank you very much, Ms. Kingsley. Always a pleasure.
Thank you, Judge.
Good luck. Thank you.
Thank you for your patience this morning, Judge. I appreciate it.
No problem.
It's an 11 o'clock.
You're Mr. Fowler?
Yes.
Come on up here.
Right to the podium here. Right here, right to the podium.
People versus John Stephen Fowler. This is 96 CD 0285000G. Your name?
John Stephen Fowler.
Were you in front of me on this case?
No, I was in front of Judge Schwank.
Wow.
He did get through to me because since this incident.
Did you have the 94 conviction set aside?
I'm trying. I'm in the process of doing both. The reason for all this is I had a Nexus card twice to be able to go to Canada for global entry. And this third.
Where's your first one apply? Where was your first one?
In Monroe County.
Well, you can't have both, it looks like to me. You can't have both set aside. Did you receive the prosecutor's response?
And it also says in the part with, we took it as up to the judges because with number of felonies or number of other misdemeanors, the number was quite high.
When is your date scheduled for the hearing in Monroe?
We don't have it yet. They're waiting on something. They were ahead of this court. Now, for some reason, they're behind us at this date. We're not exactly sure when that's going to be. The reason this all came about, trying to get a Nexus card through Canada. That's why I'm trying to do this, so I get global entry for traveling. I've had 2 Nexus cards that didn't bother me before, but with, I guess, the world politics that's going on right now, they decided not to renew it this time. So that's what brought this all about. I haven't had a drink since this incident. We're going on 29 years.
Good for you.
And, like I say, the only reason I'm here to even worry about this, I'm not applying for jobs anymore or any of that stuff. It's simply to try to get the Nexus card so I can get global entry. Canada denied me.
You can only have one set aside as I'm seeing this. And you've got two. Look, I need to look at this a little bit better. You don't have a date at all in Monroe?
No, we don't, no. We had a date and then they didn't get paperwork back from the state, from the Attorney General. So they've canceled that date and now we can go by there on the way home and see what's going on. I don't know what the holdup is. If you guys received everything, they should have.
Ma'am,
Oh,
I can't let you talk.
25th of June, I guess we have it scheduled, correct?
I'm gonna go back and look at this. Lisa, I want to adjourn this, okay? I'm sorry. I want to go back and check a couple things. The way I read this, you can't have the second set aside. So whether it's this one or the other one is not, I don't believe you can get them both set aside. But I want to go back and double check. Jennifer, let's adjourn this over a couple weeks and I will make sure I do my due diligence to find out here, okay? I promise you. If you want to appear by, where do you live at? What city?
Monroe.
I mean, do you know how to operate Zoom?
Yes, we do.
If you want to do this by Zoom, I don't have a problem.
That would be great.
Okay, where is the file? Is this it? So Jennifer or Lisa, just, I don't know what day we're going to adjourn it to. Do you want to just give them a date down there?
June 10th at 11.
All right, so we'll do June 10th at 11, okay? And I just don't really have a register to write on here. So can you put that on there somewhere?
Yep.
June 10th at 11, and then I want to see this file like a couple business days before that, okay? Thank you. I'm sorry. I'll see you June 10th at 11.
I guess this way we read the other part, we wouldn't have wasted your time. I'm hoping that.
Well, I don't think you can get both is the problem. I don't believe you can get both, and I know what you're talking about, gaining entry to Canada with this single drunk driving is not good, right? I mean,
Funny part is they already, I had 2 Nexus cards already, they okayed it twice. But due to the climate, I'm assuming, of the political forum, they've tightened up or I don't know what happened, but I've had Nexus card twice because I had all this stuff. Didn't realize that I didn't have it until we went to renew and, so here I am.
Good luck. We'll see you in a couple of weeks or 3 weeks, I guess, 2-3 weeks. Thank you.
June 10th at 11 o'clock on Zoom.
Correct. And she'll give you that information. Go down to my judicial clerk down the end of the hall, okay?
All right, very good.
Have a good day.
Thank you, Judge.
So I want that stuff given to me so you can actually, you can just copy that now for me. Did I call these LVMV versus Latif and Velocity versus Stewart? I don't remember calling Velocity versus Stewart.
That's not none of that.
You took mine.
Yeah, true. There.
That's not even on.
Taken off the doctor.
Yeah, that's what I'd like you to check on. Tabitha, have you had a chance to do those retractions?
No.
I'm gonna give you some more.
Okay.
All right. Thanks.
You got that? Are you taking care of
So
that?
we got nothing. Yeah, I'd like to see that.
11:15.